North Carolina has some of the nation's most progressive laws against domestic violence. Domestic violence cases may be pursued in 1, the civil court system, and 2, the criminal court system. Let's first talk about the civil system. In North Carolina, civil domestic laws are part of Chapter 50B of our general statutes. Chapter 50B allows a victim of domestic violence to seek relief by filing for a domestic violence protective order, also known as a DVPO or a 50B order. A protective order is a civil court order signed by a judge that provides protection to victims of domestic violence from their abuser. There is no filing fee, and victims are not required to have a lawyer when they go to court for a DVPO. However, the paperwork can be confusing to someone who is not familiar with the process. The alleged abuser in a 50B action is not arrested when he is served with the paperwork. He is not required to have a lawyer at the protective order hearing, but often does. The most commonly granted relief in a 50B order keeps the abuser away from the victim, often kicking the abuser out of the house if he lives with the victim. Other common provisions include preventing the abuser from owning a firearm and completion of an abuser treatment program. 50B orders can, but usually do not, include provisions regarding custody, support, or property. Next, the criminal process. Many of North Carolina's law enforcement agencies have proactive domestic violence policies. In these jurisdictions, if an officer has probable cause to believe an act of criminal domestic violence has occurred, the officer shall, not may, shall charge the abuser with a crime. It is likely that the person charged with a crime of domestic violence will be arrested and processed at the local jail. The alleged abuser can be held for up to 48 hours before he is released. However, in most areas, the alleged abuser is not held 48 hours unless he is arrested over the weekend. In larger judicial districts, the abuser will likely have an appearance before a judge within 12 to 24 hours. The judge sets bail and will listen to pretrial release recommendations from the prosecutor's office and the victim. As a routine pretrial release condition, the alleged abuser will be ordered to have no contact with the victim or risk rearrest. Punishment in criminal domestic violence cases depends upon the crime and the defendant's prior criminal record.